It is a time-bound disqualification which can be introduced through a statute.
Okay. Now, with regard to the disqualification of, did the law for degrees, the law did not provide a time period disqualification. So the Supreme Court, in the case of Samiullah Baloch, held that since no disqualification period has been prescribed, it will be forever.
So long as the declaration is in the field, the disqualification stays.
And the two be resolved now, if the judgment of the Supreme Court also stands and the law also stands, that till the law came into effect, that may have been the position, but since the law has now occupied the field of legislation and prescribed a particular period of time, unless we hear a challenge to the law, which there is no challenge to the law, then why should we disregard the law? That's one way of looking at it. And we don't need to touch the judgment at all, because at that time, this aspect of the matter had not been legislated upon either in the Constitution or by law. So then the courts kind of filled in the vacuum and said that it should be lifetime because there is no period of disqualification. So Samiullah Baloch judgment stays intact, but the law has come in place and it is in the nature of a non-obstante clause. That's one reading of it. What do you have to say to that?
So the question would be, can the sub-constitutional legislation control the Constitution?
So that is one, and then the second would be, can there be legislative overruling of a judgment without first removing the basis on which the judgment came out? So,
can we go to the judgment now of the Supreme Court?
My Lord,
relevant provisions, whatever you think are relevant for our reading.
Paragraphs, my Lord.
Paragraph 35 है
जी 35 and
444 page पे
जी. So this is PLD 2018 Supreme Court 405.
ये चार जजमेंट जो पहले है ना,
very important,
उनका रेफरेंस है पहले इसके अंदर ना, चार जजमेंट हैं, उसके साथ फिर समीउल्लाह है
जी.
एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलादीनो भाइयों है.
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
So, Mr. Attorney General, to nullify Samiullah Baloch, the amendment would have been in the Constitution.
My Lord, that's why I
mean, if you're looking at the basis of the judgment,
Yeah.
the basis of the judgment emanates from the Constitution. So unless the Constitution were to be amended, Samiullah Baloch could not be undone.
So, because Samiullah Baloch is interpreting a constitutional provision, and Samiullah Baloch basically holds that the declaration which is referred to in 62(1)(f) has to remain in field till such time, the declaration in the field, the disqualification stands. Then what my Lord has observed carries.
There is no time limit provided under Article 62.
So there are no time limits as far as my Lord the Chief Justice had just gone through, took us through clauses A through G. Now, as far as D, E, F are concerned, they are all without any timeline. Now, the question before your Lordship, and it was also argued in Samiullah Baloch. In fact, all the counsels before Samiullah Baloch.
If we consider that through Samiullah Baloch the Constitution has been amended, then the constitutional amendment is required, as per my understanding.
My Lord,
it is interpretation.
My Lord, with respect, Samiullah Baloch also read something into the Constitution which was not provided. And
like, what did they read into the?
My Lord, while comparing now, while examining 62(1)(f), the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h), which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that, because there is a personal price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases, the declarations are there. Now in 63(1)(h), there is a conviction which stands. It's only that.
It's really a question of interpretation, because what's very interesting, speaking for myself, if you look at 63 G, H and I,
Yes.
I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry a criminal punishment.
Absolutely.
That carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and test election. But if you just forget to write something in the form, you would be out forever. So how does one reconcile? So it's a matter of interpretation.
Yes, so that is what my respectful submission would be, because in both, in G, H and also in I, there is an adverse finding against the person, a declaration by a court of law against that person. In those proceedings, those declarations of course subsist. He serves the time or whatever punishment provided by law, and then he can come back in after 5 years. Now here, while looking at 62(1)(f), where there is this, the standard of proof is lower compared to those criminal proceedings under 63(1)(h), which is beyond any shadow of doubt, and that declaration has still come out beyond any shadow of doubt. And here is preponderance of evidence or somewhere between the two, and here the person is out forever.
But before we go into that, could you just explain to us how can any court, a civil court, grant declaration which is in the negative? I mean, how can a court grant a declaration that you're not sagacious? That cannot happen. So how does that work? I mean, I've been always perplexed about this. We can't get a negative declaration from any court. Can a court say that you're not sagacious? Why would that happen? Because no civil proceedings could lead to a negative declaration. It's always positive. So I don't understand how a court will ever give such a declaration. So then most of the courts which have given this declaration are the constitutional courts. So you have
That's another
degree
question
case.
now.
And in those cases, is the declaration absolutely clear? I mean, does it say that you're not sagacious, or then we infer from the judgment that because you presented a fake degree, as a consequence, we understand that you are not a mean? I mean, let me just go to
Yes.
the language of 62(1)(f) to understand what do we mean by declaration.
Declaration, and also what is a court of law, because, and I say this, and my lord has just observed, in Ishaq Hakwani's case in 2015, a 7-member bench actually framed these 4 questions. They left them unanswered for some other case in future, and those questions were that what would be that court which is to give this sort of declaration? What would
What
be the
happened
procedure?
then in that case?
They left it open, sir. These questions were not answered by a 7-member bench. So which court would it be? What procedure would it follow? What would be the standard of proof? And who will have the locus standi? Now these are the questions which are very, very relevant for the purposes of for this declaration by a court of law. And then also whether the courts exercising, let's say, constitutional jurisdiction, who cannot record evidence, where witnesses cannot be cross-examined, a person against whom an allegation has been brought cannot really defend himself as he is able to in a trial, would the declaration
So
coming
my
from
question,
constitutional court suffice for 62(1)?
Mr. Attorney General, the question which has been there for a while now is, first of all, can there be a civil court granting a negative declaration, number one? And number two, the question is that in constitutional proceedings, where there is no evidence being taken, the court has arrived at a decision that a fake degree has been, for example, I don't know what the other cases are, fake degree has been presented by this person, does not necessarily mean that the court is moving further and saying that you are now non-sagacious or whatever. It's simply saying in this particular matter, a false degree was presented. But I don't know of any judgment where they've actually gone ahead and said, then as a consequence, you're a fraud. So I don't know. So is there a declaration actually coming out of the Constitutional Court also? And can they, without taking any evidence, give such a declaration about a person?
My respectful submission is, my lord, that a constitutional court. Now, mindful that this 7-member bench left these questions open, but then there are two judgments. One in PLD 2015 Supreme Court 265, which is Panama 1. Justice Ijaz Afzal Khan, speaking for majority, said that a court of law for the purposes of 62(1)(f) would be a court which can actually record evidence, which is a plenary court of original, revisional, appellate jurisdiction in civil and criminal proceedings. But
without recording evidence, declaration can be given?
Cannot be given. And then the same in...
But even a negative declaration cannot be given, even if you record evidence.
Right,
I don't
right,
understand
right.
this.
And then in Aladino Bhaio, the second Aladino Bhaio, the review Aladino Bhaio, they revisited the original judgment which was given in 2013, where under it was held that once a declaration under 62(1)(f) is given, it does not go away with the flux of time.
Declaration में तो यही है ना कि person may not file his own case for declaring him Amin.
Yeah.
Somebody has to challenge his character.
That's right.
Then in that case, the declaration will come whether he is Amin, sagacious, righteous or not.
Yeah.
So ये declaration होगा ना, खुद तो जाके नहीं मांग सकता
और
declaration.
दूसरा नेगेटिव एज पर
Somebody will come challenging.
सिर्फ पैटर्निटी पे हो सकता है शायद, एक एक्सेप्शन है 42 में, देयर इज नो अदर एक्सेप्शन.
Section 42 में तो legal character कोई deny करता है तो suit file होता है ना. If somebody is denying his legal character, then he can file the suit under section 42 of the Excessive Relief Act.
What right?
और अगर आप कॉन्स्टिट्यूशन कोर्ट्स के केसेस भी ले लें ना, तो फॉर एग्जांपल somebody has not, for example election tribunal says that the nomination form में फलां चीज नहीं है, तो मिस डिक्लेरेशन इन्होंने की है. चलिए ये बात तो हो गई, इन्होंने मिस डिक्लेरेशन की. अब इसका क्या मतलब, फिर हम खुद जोड़ते हैं, हम कहते हैं कि क्योंकि मिस डिक्लेरेशन की है इसलिए फिर आप अमीन नहीं है, इसलिए 62(1)(f) लग. But the court has not said it. The court is not declaring that you are non-sagacious or not Amin. But the court is simply saying you have filed, there has been a misdeclaration in the form. So, उस पर जरा elaborate करें. How do we actually get? Where is the declaration, actual declaration from the court of law?
उसमें कहीं पर वो करेक्शन के भी प्रोविजन है, अब जो नॉमिनेशन पेपर्स हैं.
और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now, there's again very interesting because in some judgments in Sher Alam's case, for example, the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo moto notice under 184(3) and gives
quo warranto देखे ना, वो तो article 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
वो तो office में जाने के बाद है, not prior to.
जी, office में जाने के बाद होगा, but as far as that declaration is concerned, question is, can that declaration be given in those proceedings, or for that somebody has to go to civil court or some court which has the original jurisdiction to try and receive evidence, allow the person against whom an allegation has been brought to cross-examine.
एक चीज जरा देखिए, come back to Article 62.
My lord.
Read G.
He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan.
Yes. Now, if we read 62(1)(g) on its own with the judgment of Samiullah case, the ban is lifetime ban.
But
If we read them together.
Now
read 63(1)(g).
Ji.
It's the same language, ideology of Pakistan.
For
And
propagating
here it prescribes a ban for 5 years.
or the sovereignty, integrity, or security of Pakistan.
No, it's the same 62(1)(g) and 63(1)(g)
That's
are
right.
more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Sabiullah Baloch to 62(1)(g), it is lifetime ban. And if we apply 63(1)(g), it is 5-year ban. Unless you say 62(1)(g), Sabiullah Baloch is not attracted to 62(1)(g). That could be one argument. So
it's interesting what my lord has observed, because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए, तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक declaration आ जाए, तो then he's gone.
if he has been convicted and goes to jail. So his
And come
sins
back.
are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years, and if your guilt has not been established, because every criminal case has two components, conviction and sentence.
That's right.
You can be convicted and you can be sent on parole, or you can be convicted till the rising of the court, or whatever it is, or maybe not. Say for good conduct, we don't convict you this time, we don't sentence you this time, we just convict you.
That's right.
So that will be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yeah, sentence
I would
me to
rather
the
go to-
rising of the court so I can just go back after 5 years.
So see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague. And they're overlapping as well, because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens?
Hafiz, alim.
So एक तो वो समझ नहीं आ रही, लेकिन फर्क सिर्फ ये है कि F में तो ये है कि एक डेक्लेरेशन खड़ी हुई है थर्ड पार्टी की, तो जब तक वो खड़ी हुई है वो चलता रहेगा. That's what Samiullah Baloch saying. Samiullah Baloch actually turns on the declaration.
वो हुआ ये कि एक्चुअली 18th अमेंडमेंट में ये जो डिक्लेरेशन बाय कोर्ट ऑफ लॉ लाने का पर्पस तो ये था कि वो रिटर्निंग ऑफिसर्स जो है ना वो डिटरमिन ना करते रहे या इस किस्म का एलिगेशन कोई और रैंडमली ना आकर लगा दे, और ताकि ये जो डी, ई और जी के अंदर जो हो सकता है वो एफ में ना हो. Because perhaps some easy.
आपके मुताबिक
वो उल्टा हो गया.
how does D, E and G play out actually? I want to ask this question. आज से 10 साल पहले किसी ने इंटेग्रिटी ऑफ पाकिस्तान के बारे में कोई बात स्पीच कर दी, बस खत्म हो गई बात. अब वो इलेक्शन नहीं लड़ सकता.
ये देखिए कुछ लोग होते हैं तो
5 years कर दिए ना,
वो कहते हैं यस आई सीन द लाइट. अब इस्लाम में भी तौबा की गुंजाइश आखिर मिनट तक है. वो कह सकता है जी मुझे, जैसे माय लॉर्ड ने ऑब्जर्व किया कि मुझे इस्लाम के बारे में नहीं पता था, अब मैंने सारे अब लाइफ टाइम बैन उसको कर दिया कि वो फिर शायद हाफिज बन गया हो सकता है, आलिम बन गया हो सकता है, आप और बेहतर और हम सबसे बेहतर कुरान शरीफ समझने लगा हो, और वो लाइफ टाइम बैन में आ गया क्योंकि उसको 20 साल पहले या 10 साल पहले या 5 साल पहले इन चीजों के मुतालिक इल्म नहीं था.
समीउल्लाह बलूच जो है इट एक्ट्स एज अ गलिटीन. वो कहते हैं कि जब आखिरी अपील में जब आप आएंगे तो बस उसके डिसीजन से पहले तो अगर आप रिपेंटेंस कर लें तो हो सकता है, वरना वंस that happens then there is no repentance.
कहाँ छोड़ा?
नहीं छोड़ा. 184(3) में तो वैसे ही नहीं होता, बट अदरवाइज भी नहीं.
रिपेंटेंस कहाँ लिखा हुआ है
साहब सुनने जरा, जी साहब
समीउल्लाह बलूच
देखें, इसमें असल बात यह है कि डिफरेंस हमने मालूम करना होगा 62 63A में. व्हाट इज द डिफरेंस बिटवीन द टू? एज फार एज आई एम कंसर्न 62 is not giving power to decide against a person. देखिए इसमें तो सिंपल ये इट इज डिपेंडेंट अपॉन 63. 63 में जो कार्रवाई करेंगे वो दिखाएंगे, 62 में वो कहेंगे यू आर नॉट क्वालिफाइड. वेयर एज डिसक्वालिफिकेशन इज इन 63. अगर कोई शख्स सपोज कोई काम करता है, कोई गलत काम करता है, तो अगर आप जी और एच को पढ़ लें, जी और एच वो डिटरमाइन करते हैं कि कोर्ट ऑफ लॉ से जब उसको कोई डिक्लेरेशन हो, ये उस डिक्लेरेशन की बात हो रही है. आई थिंक सो
जी.
इस पे बात करें कि ये 62(1)(f) कहाँ पे पावर देते हैं कि आप इतने टाइम के लिए डिस्क्वालीफाई हो, इतने टाइम के लिए? वो तो सिर्फ ये बताते हैं कोई शख्स पेपर सबमिट हो रहे हैं उससे पहले बता दिए कि जी फला कोर्ट से इसको सजा हुई लिहाजा पेपर खारिज, दैट्स ऑल, मैटर एंड्स. The authority dealing with this matter have no power to decide the disqualification period of that person. वो disqualification के period तो 63 ने बता दिया, ये सजा जुर्म करोगे तो इतनी सजा होगी, और उस जुर्म की सजा पूरी होने के 2 साल बाद जब आप निकलेंगे तो फिर आप क्वालिफाई होंगे.
तो
ये आप जो पहला सवाल जो आपसे किया कि डिफरेंस, आप डिफरेंस जब बताएंगे तो खुद ब खुद पता चलेगा व्हाट इज 62 एंड व्हाट इज 63.
So if 62(1)(f) is juxtaposed with 63(1)(h),
H and H both.
H moral turpitude.
H moral turpitude है because वो उसके साथ dishonesty etc. वो उसके साथ है moral turpitude being very broad, और वो examine हुआ similar belief, उसको अगर आप सामने रखें तो the consequence then, if they are to be reconciled, then the consequence is only one, which is that the timeline which is provided for the declaration in 63(1)(h) must necessarily apply to the time to the
फर्क ये हो गया ना
declaration
कि H में अगर conviction हो गई because it attracted an offense and so it led to conviction, then he can come back. But if it was lesser than even a case where it could constitute an offense and so he could not be taken in a criminal case, a simple declaration was given on the civil side, that goes on unlimited. अब यही समझ नहीं आती, because otherwise then we also have to stay away from the concept of reading into the constitution.
But now that you have started reading in
So
63A, so I was just
that is also a question.
So you must stop from reading furthermore.
Reading in to
Just another aspect, if you can attend to, can you read D
my lord.
again?
He is of good character and is not commonly known as one who violates Islamic injunctions.
Now please read F.
He is sagacious, righteous, non-profligate, honest and ameen, there being no declaration to the contrary by a court of law.
Now, what does this mean? There being no declaration to the contrary by a court of law. In clause D and in clause E and in clause G, these words are not mentioned.
That's right.
So either you say clause D, E and G are redundant, they're meaningless clauses, because the words there being no declaration, either the same wording should have been followed. And I can't, at least I cannot understand the difference between good character and sagacious. I mean, good character is something different from sagacious. Is good character different from being righteous?
Righteous,
non-profligate. What does that even mean? What does non-profligate mean? What does it mean?
Who doesn't spend wastefully?
Israf.
Yeah.
So good character.
Yeah.
So if you are doing wuzu and wasting water, you become a profligate. Because there's a hadith of the Prophet,
That's right.
do not waste water, and even if you're standing next to a flowing river. So then he's a profligate. So, and then we go honest. Good character, every good character person is an honest person, I would imagine. And Ameen. I mean, you know, these are words which a Muslim would never even dare utter in deference to the Holy Prophet, that only he is and none of us are. I mean, that is humility and abject humility. You will never say that. Otherwise, why would you seek forgiveness for whenever someone dies? Please forgive his sins. Do we ever say he's entitled to Jannat and Allah Ta'ala grant him Jannat? He never committed a sin. We don't even pray that for ourselves. No honest person will say any of these things, that he's sagacious, righteous, non-profligate. Even the greatest saints in Islam were scared when they were dying, that they were scared of death because they were apprehensive of what may they be meeting in the hereafter. So I don't know, is this generally a wish list kind of situation as opposed to because otherwise everybody can, if I was filing a lamination paper and if someone says he's not of good character, I would not even challenge it. I said, I'm sure I've done something wrong in my life. Maybe I've done it wrong yesterday, so I don't know. So if you're honest and you say, right, this person is right, I am not sagacious, righteous, non-profligate, honest. I do not switch off the lights when I go out of a room. I waste electricity. I waste human resources which the Almighty provides. So where does it end then? I can bring any case into disqualify someone, and I want to save someone, I can also do the same thing.
That's why-
Should such power vest in judges
And
who are
that's-
themselves humans?
That's why
They
critical.
want a greater test for parliamentarians than they have for themselves. Does this language find mention in the oath of office of a judge? That I'm not profligate? Does it mention in the recommendations of a judge? All it says you have to be 45 years of age, practicing law for 10 years.
It could be
So
profligate.
we have a lower standard than parliamentarians. Why is this language then not reflected there as well? Let's accuse ourselves before we accuse anybody else what they are or what they are not. So either we have a much lesser test, we can't, at least I would be very scared to meet this test, terrified to meet this test. So either we don't have a similar test, so we have to read the Constitution as a living whole, and where the Constitution has brought down the acts, it clearly says 2 years, 5 years, 3 years, 2 years, or it's factual, you're not a citizen, fine, that's very clear. There is no punishment here, but you're out. So without a punishment, you're out. There's no punishment. So, but suppose a person is a citizen of Pakistan, not a Pakistani citizen, but becomes a citizen of Pakistan later. Would he stand disqualified for life? Suppose he filed a nomination paper and he had another nationality or whatever, and he got disqualified. Is it disqualification for life? And then subsequently he said, okay, I've surrendered my US nationality and now I want to contest. So I don't know, we have to read it in a way that is meaningful. And we must bear in mind the conditionalities that were imposed to exclude people from this, the degree situation. Thankfully, it wasn't there when the Qaid was around, because he would have been disqualified.
That's right.
He wasn't a graduate.
ये amendment कब हुई? ये amendment
2002 की 8 की
2002 में
55.
किसने की amendment?
This
My
was
lord,
brought
this
to the
was
eighth.
presidential order.
क्या वो president खुद इन पे उतर सकता था, इन तमाम requirement पूरी कर सकता?
But ये general military general Ziaul
शुरू में नहीं
Haq
होते, बाद में डिग्रीज करते हैं. शुरू में नहीं होते. FSC
Non elected members अगर amendment करेंगे तो यही होगा.
Mr. Attorney General, the question is that while we're looking at D, E, and G, which to my mind appears to be a guideline for the voters, the actual gatekeepers, and they might keep this in mind when they're voting because nobody can execute them and put anybody behind anything. So D, G, E, and G to sir guideline ho sakti hai voters ke liye, and that's never been agitated. The $1 million question is, how do we look at the line, no declaration to the contrary by a court of law? What do we do with this? This is
My
in the
lord,
Constitution.
if I may,
I think my lords have raised the questions. Can we read the law on declarations? What is the law on declarations? Section 42 of the
Section 42 of the Special Relief Act.
I would
legal
imagine,
character.
is that the only declaration that has been indicated here?
There's no other declaration. और तो कोई है ही नहीं.
कोई और law होता है declarations का? ये Specific Relief Act.
Only Special Relief Act, Section 42. Legal character के ऊपर जो है ना, वो that is the only law.
Declaratory suits are filed under 62(1)(f).
हो नहीं
Section 42.
Constitution में रहा. ये तो
इन्होंने कर दिया ना, बट अगर कोई चैलेंज करेगा तो वो तो 42 में ही करेगा ना. वो नेगेटिव डिक्लेरेशन.
Negative declaration concept है ना. Positive declaration is not the negative declaration. We have held in paternity cases that you cannot do negative declarations.
paternity can
किया ना, negative, positive.
negative कर सकते हैं paternity.
नहीं, negative, positive, हाँ. Negative नहीं हो सकता है क्या?
Person regularly character right of any property.
दे देना इनको specific relief act सर. आप अटर्नी जनरल को दे देना.
कह सकता हूँ कि हम honest.
यही दे देना प्लीज.
ये मैं दावा फाइल कर सकता हूँ कि झूठा नहीं, honest.
Yes. Ji.
But that's an entire.
Ji, sir. I have it before me. Mr. Jilani's iPad is very helpful. Discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief. Bar to such declaration, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so.
By the court, to what is understood by court? A civil court?
Yes.
Under section 9, or is it a constitutional court?
Now, it's a civil court where evidence can be led, witnesses can be examined, where a burden of proof is discharged, and then there is an opportunity of rebuttal.
Suppose in a case where I've done so even, we observe hearing a civil petition for leave to appeal or an appeal that the appellant had dishonestly filed a suit. Suppose we hold that, and we've held so, and impose costs on him. Will that constitute a declaration of a court of law in terms of Article 62(1)(f)?
My respectful submission is no, sir.
Why?
Because you are not a court where that particular issue is actually conclusively determined through a trial.
So we could observe in other cases. We could say in a criminal case that I don't believe this witness is a liar. And that witness will then be struck by 62(1)(f) because it's a declaration of a court of law. In a judgment in a criminal case, he was not an accused there, but he was a witness. And the court says, I don't trust this witness, I found him to lie.
Yeah. My lord,
So it's, then you can bring out every case. We may make an observation against a lawyer. He misled the court, for instance. Sometimes we do that.
My lord, if I-
Regretfully. And then if a lawyer contests election, the person will say, you have held that he misled the court. He is, of course, how can you allow him now to contest an election? He's banned for life.
my lord, now,
जी साहब एक चीज और देख लीजिए, डिक्लेरेटरी जजमेंट्स का जो सुप्रीम कोर्ट के लिए प्रोवाइडेड है ना, वो आर्टिकल 184 सब आर्टिकल 1 में वो डिक्लेरेटरी जजमेंट्स हैं सूबे और वफाक के दरमियान जो झगड़े होते हैं ना, उसमें लिखा हुआ है कि सुप्रीम कोर्ट शैल प्रोनाउंस डिक्लेरेटरी जजमेंट. उसके अलावा के डिक्लेरेटरी जजमेंट 184 और 185 में लिखा हुआ है.
no, 184.3 is not mere declaration. I mean, 184.3, the court goes on to conduct.
शिजा शौकत साहब यहाँ बैठे हैं जो सिविल कोर्ट के माहिर हैं, तो आप बताइए ना ये वाली डिक्लेरेशन कैसे होगी?
My lord, दो चीजें ऐड कर
पे
दूं.
बता दें.
आप सपोर्ट कर रहे हैं लॉ को या अपोज कर रहे हैं लॉ
But I'm supporting the law.
The law.
I'm
We
against.
want to hear from those who are opposing the law.
There's none.
So then-
apparently
नहीं,
there's
there
no
is
one
somebody who said yes.
there. Then hear him out.
ये है ना.
जी.
I am opposing this.
So, yeah, I think in the course of proceedings,
Let's hear.
the
I
challenge.
just want to understand how the opposition is.
That's right.
जी बताइए.
ये आप अपोज कर रहे हैं तो पहले ये बताइए कि इसको
oppose
चैलेंज
कर रहे
किया है.
मतलब मैं लॉ को इस बारे में अपोज कर रहा हूँ.
नहीं, पहले बताइए कि अगर है तो हाई कोर्ट में चैलेंज किया वायरिस को इसकी आपने,
मैंने तो चैलेंज नहीं किया.
फिर अब क्या अपोज करेंगे आप?
गुजारिश ये मालूम, क्योंकि समीउल्लाह बलोच केस अगर मौजूद है जो कि कॉन्स्टिट्यूशन कर रहा है,
माइक अपने सामने.
तो इसीलिए तो आपसे पूछा ना, समीउल्लाह बलोच है, उसके बाद आप समझते हैं कि लॉ गलत अमेंड हुआ है, 232 गलत आ गया है, तो वेदर यू हैव चैलेंज द वायरिस इन द हाई कोर्ट और नॉट?
that can be challenged before this proceeding, my lord, because that question is just alive before the honorable, and the same notice has been issued on that question. And in this proceeding, this honorable court has every authority to declare the law which has been passed in violating the provision of the constitution or whereby.
पर अभी उस्मान आपने कहा था कि are you supporting life disqualification or
I'm
सर मैंने कहा था कि I am
नहीं उस्मान ने क्या कहा था?
मैंने ये कहा है मालूट कि जब तक समीउल्लाह बलोच मौजूद है ये लॉ नहीं आ सकता, ये लॉ अल्ट्रा
पर मेन केस में आपकी क्या है कि डिस्क्वालिफिकेशन लाइफ को आप सपोर्ट करते हैं या नहीं?
मैं डिस्क्वालिफिकेशन को असिस्ट मैं इस पॉइंट पे करना चाहता हूं कि रीविजिट हो सकता है कानून, लेकिन वो इन कंडीशंस के साथ रीविजिट हो सकता है. वो मैं
एक देखें, वजाहत से बात कीजिए ना, गोलछोल बातें ना कीजिए ना. आप लाइफ डिस्क्वालिफिकेशन के फेवर में या खिलाफ हैं? सीधी बात
मैं
करें
लाइफ
ना.
डिस्क्वालिफिकेशन की फेवर में उस हद तक हूं कि अगर समीउल्लाह बलोच prevail करता है.
آپ سے سیدھی
اگر
بات
نہیں
پوچھیں
prevail کرتا,
ہم یہ کیا سوال جواب دے رہے ہیں آپ؟
نہیں, either you support the principle or not.
لا کو سپورٹ میں اس لیے نہیں کر سکتا کہ لا اگینسٹ دی ججمنٹ آف دی سپریم کورٹ ہے.
اگر against the judgment ہے,
انٹرپریٹیشن ری انٹرپریٹ ہو سکتی ہے پروویژن.
سپریم کورٹ کا ججمنٹ جب تک تھا اس کے بعد پارلیمنٹ نے لا امینڈ کیا. اگر آپ یہ کہہ رہے ہیں اس کا مطلب ہے کہ سپریم کورٹ کی ججمنٹ کے بعد پارلیمنٹ لا نہیں بنا سکتا.
لا بنا سکتی ہے اسٹیچوری انٹرپریٹیشن کے بارے میں, جہاں اسٹیچوٹ انٹرپریٹ ہوا.
چلے لا کا تو ٹھیک ہو گیا, but are you saying that the principle settled in Samuel Baloch, you agree with it?
No, that I don't agree. I want to say that there is some conditions for the on the basis of state decisive principle کہ کب وہ ججمنٹ جو ہے وہ ریوزٹ ہو سکتی ہے اور کیا وہ conditions.
آپ بار بار وہی چیز ریپیٹ نہ کریں نا, آپ سیدھی بات ہم سے کر نہیں رہے ہیں. ججمنٹ کو چھوڑ دیجئے 2 منٹ کے لیے, لا کو بھی چھوڑ دیجئے. ہم صرف آپ کی رائے معلوم کرنا چاہ رہے ہیں. آپ لائف ٹائم ڈسکوالیفیکیشن کو 62(1)(f سپورٹ کر رہے ہیں یا نہیں کر رہے ہیں؟ کچھ ہاں یا نہ تو کر رہے ہیں.
میں نہیں سپورٹ کر رہا,
نہیں کر رہے ہیں. اچھا, ہم سننا چاہتے ہیں کہ کون سپورٹ کر رہا ہے. ایک سیکنڈ ٹھہر جائے, ہم لوگ سنیں گے آپ کی وقت پہ. قانونی بات کریں گے تو کریے. آ جائیں, بتائیے. ایک سیکنڈ, لیٹ اس ہیئر مسٹر سمیع اللہ بلوچ, دی پرسن.
جی,
ثناء اللہ بلوچ.
شکریہ جج صاحبان.
یہ آپ کا یہ کیس ہے؟
جی سر, یہ میرا یہ کیس ہے.
یہ تو لکھا ہے سمیع اللہ بلوچ.
Sir, Samiullah Baloch is my brother, and Abdul Karim Nosharawani, I am the aggrieved person because I contested the election against
سمیع اللہ بلوچ کہاں ہے؟
Abdul Karim Nosharawani. Sir, he is my brother because the case is mine. So,
آپ ان کے اٹرنی ہیں, آپ کیسے آپ پیش ہوئے تھے کل؟
جی میں پیش ہوں سر, بیکاز میں ایگریوڈ پارٹی ہوں. جو میں نے 2002 کے بعد جب الیکشنز ہوئے, میں اس کی تفصیلات میں گراؤنڈ یہ ہے کہ جو کانسٹیٹیوشنل جو پرنسپلز ہیں اس کے تحت سپریم جو جوڈیشل سپریمیسی ہے اس کو مد نظر رکھتے ہوئے
یہ ایسی باتیں نہ کریں عدالت میں. جوڈیشل سپریمیسی کیا چیز ہوتی ہے؟
میں سر اگر آپ کی اجازت.
نہیں, ایسی باتیں نہ کریں ہم سے. کانسٹیٹیوشنل سپریمیسی کی بات سنی تھی ہم نے, اب آپ جوڈیشل سپریمیسی کا میں نے کانسیپٹ نہیں سنا ہے.
سر یہ جو
نہیں, دیکھیے قانونی بات کریں نا, یہ ایسی باتیں نہ کریں.
سر یہ جو آرٹیکل 62 اور 63 ہے, یہ کانسٹیٹیوشن میں گزشتہ 50 سال سے اور بالخصوص 18ویں ترمیم کے بعد اس میں کچھ ترامیم ہوئی, لیکن پرٹیکولرلی 62(1)(f) میں ترامیم نہیں کی گئیں. یہ ٹوٹل 5 صفحات پر مشتمل کانسٹیٹیوشن کے اندر بہت کلیئرلی انٹری اور ایگزٹ پوائنٹس دیے گئے ہیں حق کے نمائندگی کے لیے, اختیارات کے لیے. کہنے کا مقصد یہ ہے کہ سر جب یہ 2013 کے بعد سے جب یہ
اگر آپ کہہ رہے ہیں نا 50 سال سے یہ اسٹیچوٹ بکس پہ ہے, تو پہلے کیوں نہیں کبھی کوئی ڈسکوالیفائی ہوا؟
میں اس پہ آ رہا ہوں سر. بات یہ ہے کہ سر یہ جو ہے 2002 کے بعد سے زیر بحث آیا. یہ 20 سال سے سر سپریم کورٹ اور بلوچستان ہائی کورٹ اور دیگر کورٹس میں یہ تفصیل کے ساتھ یہ زیر بحث رہا ہے موضوع, اور اس میں 62 اور 63 کی بہت کلیئرلی کیئرفلی میٹیکولسلی جو ہے سر اس کی تشریح کی گئی ہے مختلف.
میٹیکولسلی ایسے تو نہ باتیں کریں نا آپ,
سر میں
پوائنٹ پہ آ جائیں.
پوائنٹ پہ آتا ہوں. تو سر جب ایک کانسٹیٹیوشن کے اندر جب 63 کی جب بات کی جا رہی ہے کہ وہاں 5 سال کا تعین کیا گیا ہے, کیوں 62(1)(f) میں نہیں کیا گیا؟ اس کی بنیادی وجہ یہ ہے سر, جب میں ایز اے ممبر پارلیمنٹ میں جاتا ہوں, جب ڈکلیریشن دیتا ہوں, وہ اوتھ ہے. میں اوتھ میں یہ کہتا ہوں کہ میں شہری ہوں, میں نے BA پاس کیا ہے, میری عمر 25 سال ہے. یہ جب میرے خلاف جس شخص نے کنٹیسٹ کیا تھا, جب میں نے اس کو کنٹیسٹ کیا کورٹ میں, اس کی عمر 24 سال تھی. الیکشن میں کیونکہ اس کے پاس والد کے پاس BA کی کوالیفیکیشن نہیں تھی, تو اس کا کیا ہوا کہ اس میں 5-6 مس ریپرزنٹیشنز کی, اس میں فراڈری کی, اور جو ڈگری ہے
فیکٹس پہ نہ جائے نا. اب یہ بتائیں, جلدی بتا دیں کہ
اس جگہ سوال ہے آپ سے. آپ یہ کہہ رہے ہیں نا کہ یہ جو ڈکلیریشن جو ہمیں سمجھ نہیں آ رہی سچویشن کی, وہ یہ ہے کہ میکسیمم جھوٹ بولا نا اس نے, فارم میں جھوٹ بول دیا, مس ڈکلیریشن کر, تو جھوٹ کی سزا یہ ہے کہ ساری عمر کے لیے الیکشن پروسیس سے آؤٹ ہو گیا. یہ لکھا ہوا ہے. دوسری طرف ہم پڑھتے ہیں تو اگر قتل بھی کر دیا, ٹریزن بھی کر دیا, تو پھر بھی کچھ ٹائم گزرے گا تو واپس آ سکتا ہے. یہ بات ریکنسائل نہیں ہو رہی ہے.
سر یہ جو کیس آپ کا سمیع اللہ بلوچ آپ کے سامنے,
آپ اپنا بتائیں.
میں اپنا بتا رہا ہوں سر.
میں آپ کو آپ کیس کو 1 منٹ رہنے دیں, آپ اپنا ویو بتائیں.
میرا ویو یہ ہے سر
بینگ اے پولیٹیشین, آپ بتائیں
کہ 63 کے بعد جب کسی شخص کو سزا ہوتا ہے تو وہ ایک استغما ہے, اس کے ماتھے پہ ایک داغ لگ جاتا ہے, وہ 2 سے 4 سال قید کا گزارتا ہے. پورے معاشرے میں اس کی فیملی سفر کرتی ہے, فائنینشیل سفر کرتا ہے, مورلی سفر کرتا ہے, اس کی جاری سوسائٹی میں اس کی اہمیت اور حیثیت کم ہو جاتی ہے. اس کے بعد جب وہ نکلتا ہے تو اس کے بعد اجازت ہے کہ 5 سال کے بعد وہ جائے, اگر اس کے پاس گنجائش ہے وہ ہم کے پاس جائے. لیکن اس میں سر جب آپ انٹری پوائنٹ پہ جھوٹ بولتے ہیں, جب آپ داخلے کے وقت
نہیں, جیسے آپ نے کہا, دیکھیں ایک پوائنٹ لیتے ہیں, 24 سال کا تھا, آپ نے کہا کہ اس وقت وہ 25 سال کا نہیں تھا. 24 سال کا تو صرف ایک ہی پوائنٹ ہوتا, اس کے ڈیکلریشن پہ آپ نے اس کو چیلنج کر دیا, وہ پروو ہو گیا کہ 24 سال کا ہے. آپ کی رائے میں وہ فار لائف ڈسکوالیفائی ہو جائے گا, پھر وہ الیکشن کنٹیسٹ نہیں کر سکتا. از اٹ یور پوائنٹ؟
ود یور آنریبل پرمیشن سر, اب وجہ کیا ہوئی اس وقت؟ یہ میری وجہ,
یہی پوائنٹ ہے آپ
سر. میری یہ پوائنٹ اس وقت اس لیے سنی جب نہیں گئی, وہ شخص داخل ہو گیا, اس نے بیریئر کراس کر لیا, وہ جھوٹ کے باوجود وہ بلوچستان میں وزیر داخلہ بنا, جو ابھی سے پہلے کیس.
پھر ذاتیات پہ نہ جائیے.
نہیں سر,
ہم ذاتیات کو چھوڑ دیجئے, ہم آئینی نقطے کی بات کر رہے ہیں. ہو سکتا ہے بہت برا آدمی ہے, ہم اس میں نہیں جانا چاہتے, تو آپ ذاتیات کو چھوڑ دیجئے, آئین کی بات کریں. آپ پارلیمنٹیرین ہیں نا, ہم ذاتیات پہ بہت سکتا ہے اچھا آدمی برا آدمی, وہ ہمارے سامنے بحث نہیں ہم نے کریں گے, کیونکہ ہم ایک جنرل پرنسپل تعین کرنا چاہ رہے ہیں.
اب ثناء اللہ بلوچ صاحب دیکھیں, میں آپ کو بتا رہا ہوں جو ہمارے لیے کمپیریزن میں پرابلم آ رہی ہے نا, ایک طرف 63A میں آپ جتنا مرضی کرائم کر دیں, آپ کچھ عرصہ سزا کاٹیں, 5 سال گزاریں تو واپس آ جائیں. ہمیں یہ پرابلم ہو رہی ہے کہ سول ڈیکلیریشن میں سزا نہیں ہے, کوئی سزا تو اس نے نہیں کاٹی, سوائے یہ سزا اس نے کاٹی کہ وہ والا الیکشن مس ہو گیا اس کا. اگلے الیکشن میں تو وہ آ سکے نا. اب یہ کہنا کہ اگلے الیکشن میں بھی نہیں آئے گا, کبھی بھی نہیں آئے گا, یہ ہمیں سمجھ نہیں آ رہی کہ سول اس نے جھوٹ بولا, جھوٹ کی سزا آپ نے دی کہ تم اس نامینیشن پیپر ریجیکٹ ہو گئے تمہارے, تم نے الیکشن نہیں لڑا, سزا مل گئی نا. جو کرمنل سائٹ پہ اس کو ویسے سزا مل رہی, سول سائٹ پہ یہ سزا ہو گئی. اب آگے چلے نا, اب وہ کیا اس نے جو ایک جھوٹ بول دیا, مس ڈیکلیریشن کر دی, اب وہ ساری عمر کیسے. دوسری طرف پھر تو ہونا آئین میں ہر جگہ لمیٹیشن ہے, ٹائم کی سٹوری ہے ہر جگہ, تو پھر اس جگہ بھی تو کچھ ہونی چاہیے نا. عجیب لگا.
میں اس حق میں ہوں کہ 232 ابھی جو جھوٹ
میں اس حق کی بات چھوڑ دیں نا. اگر دیکھیں, اچھا ایکچولی آئی ایم اسپاٹنگ از دیٹ مختوم علی خان, کین وی ریکویسٹ یو ٹو, since Mr. Makhdoom Ali Khan has written on the Constitution, I don't know if he's involved in any case before us. Are you in these matters? Huh?
Yes. My lord.
Which case are you in?
I have filed a CMA 6 of 2024.
For whom? In favor of disqualification or lifetime or not?
My lord, not in favor.
But you're not in, why, who have you filed it for?
For Mr. Jahangir Khan Tareen, my lord.
Okay. Now, one thing which nobody has attended to yet, at least one way of interpreting the Constitution is what the original Constitution said. And this Constitution has been, I don't know what's the correct word, changed or ravaged from time to time, what you want to use it. Can we read the original Constitution as it was enacted in 1973?
My lord.
And see what the Constitution then said.
My lord, I will read that provision to your lordship.
Would you like to do it, or shall we ask the Attorney General to do so?
As your lordship pleases, the history is...
No, we were thinking of appointing you as amicus, but you are representing a party, so anyways, let's...
As your lordship pleases.
Nahi, padhe 62. Do you have the original Constitution?
Yes, my lord, I have, and the history is traced in Samiullah Baloch.
No, we want to read the actual text.
Yes, my lord. The text is there.
85.
Ye de de inko.
Yeah, we have it, my lord.
Qualifications for membership of parliament.
Can you come to one of the other mic?
My lord,
benefit of...
My lord, Article 62, there used to be only 3 qualifications. One, he is a citizen of Pakistan.
Read the whole article.
My lord, a person shall not be qualified to be elected or chosen as a member of parliament unless he is a citizen of Pakistan. B, he's in the case of the National Assembly not less than 25 years of age and is enrolled as a voter in any electoral roll for the election to that assembly. C, he's in the case of the Senate not less than 30 years of age and is enrolled as a voter in any area in a province, or as the case may be, the federal capital or the federally administered tribal areas from where he seeks membership. And D, he possesses such other qualifications as may be prescribed by Act of Parliament.
So these troublesome provisions were not there.
No, my lord.
When did they come into?
My lord, by Presidential Order number 14 of 1985, which is also called the Revival of the Constitution Order.
This is General Zia.
General Zia, when the martial law was coming to an end and partyless elections were soon to
Is
be
it
held.
ironic that a person who violates the constitution of the country puts in these conditions? I find that a bit troublesome, isn't it?
Yes, he after D.
Was he of good character? If he violates the oath that he took to uphold and protect the constitution, and he destroys the constitution, it's very ironic for me that he inserts a good character, knowledge of Islamic teachings. I wonder which knowledge of Islamic teaching mandates judges to be sent home because they don't swear an oath of fealty to the martial law administrator. What is your view on that?
My lord, these are, with great respect, all these provisions which have been added by the RCO or the Presidential Order 14.
Was he non-profligate?
My lord, these are matters which I would say.
Yeah, we want your answer on this.
My lord, these are matters for divine judgment. These are matters for divine judgment.
You mean to say matter of treason is for divine judgment?
My lord, no. And treason is not an issue, but if we come to treason, then in
martial law is admitted?
Yes. If it comes to an act of treason, then in that particular case.
Do you think he committed treason or not?
My lord, in your lordship is talking of 1977.
You're talking about, yes.
Your lordship will then have to examine it.
You know, we are asking your opinion.
My lord, I would be bound by the judgment of this honorable
court. We are asking your opinion.
My opinion is different, but the judgment of this honorable...
Share your opinion with us.
The judgment of this honorable court in Begum Nusrat Bhutto's case takes a different view.
चले आप नहीं बताना चाहते रहने दें फिर.
My lord, my view...
चले बाकी पढ़ लेते 63. तो ये D तक था. There was no present D, present E, present F and present G.
Yes, my lord. The D...
and 63 was also pretty succinct.
Yes, it was, my lord. 63 was also very limited.
कैसे उसमें हम पढ़ लेते हैं यही समझ
ये सारे
नहीं ला सकते ना
My lord, 63, a person shall be disqualified from being elected or chosen as and from being a member of parliament if A, he is of unsound mind and has been so declared by a competent court, or B, he is an undischarged insolvent, or C, he ceases to be a citizen of Pakistan or requires the citizenship of a foreign state, or D, he holds any office of profit in the service of Pakistan other than an office declared by law not to disqualify its holder, or E, if he is so disqualified by Act of Parliament.
So it was pretty straightforward and simple.
It was.
And RCO kind of molded the constitution.
Yes. RCO changed it in two respects. It brought in these qualifications and added a whole host of disqualifications as well.
By a person who was of sagacious, righteous, non-profligate, honest and good character.
Yes.
Yes.
But the point is 18th Amendment stamped on it. You see,
My lord, 8th Amendment stamped on it.
No, देखिए,
and then 18th Amendment stamped.
Mr. Makhdoom Ali Khan, at least now I will speak for myself, I don't know. Wherever this is one way of interpreting the Constitution, and I've held it in a judgment or two, that wherever there is problem areas or difference of opinion or two interpretations possible, at least I've chosen the one interpretation which found mentioned in the original pristine constitution chosen by the directly elected representatives of the people and not martial law administrators. Why are you so scared of martial law administrators to utter these words, Mr. Makhdoom Ali Khan?
My lord, may I submit that this is also the jurisprudence of this court. In Al-Jihad case, Mr. Justice Ajmal Mia took the view that if there is a conflict or tension between two provisions of the Constitution, one which was enacted at a time when the Constitution was in abeyance and other at the time when the Constitution was in full force, it is the latter which will then prevail, and that view has been reiterated in Samiullah Baloch, though the principles drawn from it thereafter are different. So what your lordship is observing,
Where is it mentioned in Samiullah Baloch?
my lord, in the Samiullah Baloch case itself,
No, I just want to read that part.
yes, my lord, your lordship will see the constitutional principle is identified in the Samiullah Baloch case itself at page 435. Page 435.
At this point that you are saying.
Yes, yes, my lord. This point is there on page 435. This is PLD 2018 Supreme Court 405.
Which paragraph are you reading?
Paragraph 22.
G.
If your lordship will see, there are a number of judgments cited, and then it says reference by the President, PLD 1957, Supreme Court 219 at 235. As such, the Constitution must be interpreted as a whole because it is an organic document that is meant to apply to the changing circumstances of time and space. Consequently, each provision of Constitution or part thereof has purpose, meaning, and integral place that must be understood, acknowledged, and applied harmoniously. It is only when a conflict between two provisions of the Constitution is irreconcilable and one of such provisions was inserted when the Constitution was held in abeyance, then the provision which was made part of the Constitution during the period of its abeyance would yield.
But would it apply because it, after the 18th Amendment having stamping it, so it's not really, that was a democratic dispensation of that time.
My lord, it was, but your lordships prior to this also in Al-Jihad's case took the view that in spite of the fact that whatever General Zia had done had been validated to a large extent by the 8th Amendment to the Constitution, this honorable court took the view that, and that was in particular, my lord, in relation to a provision where a judge of the High Court declined to go to the Federal Shariat Court and was as a result sent home. Their lordship took the view, particularly Mr. Justice Ajmal Mia, that this provision was inserted at a time when the country was going through a period of constitutional abeyance. No doubt it was validated by the 8th Amendment, but if when we examine it and juxtapose it with other provisions relating to judiciary, this having been added at the time cannot be allowed to hold sway, and that is why their lordships held that a judge of the High Court cannot be sent to the Federal Shariat Court against his will, and if he refuses, will not cease to hold the office of a judge of the High Court. So, in spite of that, this has been the jurisprudence of this honorable court, that in spite of the validation.
Mr. Makhdoom Ali Khan, but would you put validation at par with an original enactment which has been thought about, carefully considered by every member of parliament? A validation was also a bitter pill for the parliamentarians to swallow. If you don't validate, I continue. So it may be that, okay, we are getting something, is better than nothing, let's at least get on with it. But we are now faced with a problem. So simple validation, when the original constitution said something else, if there are two possible ways to interpret something, and more so when what has been added is very ambiguous. I don't know why these vague words were introduced. You could have simply said A, B, C, D, like every other thing is factual. Either it's a yes or it's a no. Are you of good character? Please don't answer this question. But which person would say this? I mean, it would be a very audacious person who would say, I'm honest, Ameen, and everything. And then probably he will be making other claims which will be totally not permissible. So simple validation is a bitter pill which has been swallowed from time to time to get democracy back on the rails. Would you not agree with that, since we consider you a constitutional expert, to consider validation at par with a constitutional provision, or it has to be read in the context of, because this judgment also says in space and time. The space then was a dictatorship. Either you continue another 10 years of a dictator or get some sort of a diluted form of democracy, get us back on the rails, whichever is better. So probably the parliamentarians, we should not always condemn the parliamentarians. We should see the difficult circumstances that they work under. I mean, we should respect them. And what would you have done? Let's put yourself in the position of parliament, make yourself a parliamentarian then, that you would, validate something which you may not be very happy with, but at least get the business back on track. How would you personally attend to it?
My Lord, my respectful submission is that though the earlier two judgments which I have just identified by this Honorable Court do not put it in the terms that your Lordship has, but that was probably at the back of their mind when they said that an amendment made during the period of constitutional abeyance, if it is in conflict with or cannot be reconciled with the provision originally enacted in the Constitution, then the latter will prevail. So obviously this Honorable Court has not treated the validation at the same level as the original Constitution, recognizing all the difficulties which your Lordship have articulated, but not articulating them in this particular manner. Otherwise, my Lord, if any amendment made to the Constitution, eventually when made, stands on the same plane as any other constitutional provision, but your Lordships have held that we will distinguish between constitutional provisions made during a period of constitutional abeyance.
What's your main argument? Is this your mainstay of your argument?
My Lord, my main argument in this particular case would be that insofar as when your Lordship examines Article 62 and 63, because some of these amendments, as your Lordship has just now noticed, came in at the same time, there is a relationship between the two. And with great respect to this extent that Samiullah Baloch says that 62 and 63 have to be looked at through different lenses, it is with great respect incorrectly decided. Because when your Lordship looks at 62 and 63 and the amendments came about at the same time, 62F, which your Lordship is looking in particular, which says he's sagacious, righteous, non-profligate, honest, and Ameen, there being no declaration to the contrary by a court of law, and your Lordship examines it with 63(1)H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. They are to be read together.
I mean, that is dependent upon, 62 is dependent upon 63.
63, and I would go to the extent of saying that when your Lordship looks at G, for instance, he has not after the establishment of Pakistan worked against the integrity of the country or opposed the ideology of Pakistan. It has to be related to H, which says he has been on conviction for any offence involving moral.
So what does that mean? I mean, where does that leave these provisions 62?
My Lord,
what's the effect?
My submission would be that unless there is a conviction, and that would be the declaration I would be seeing, not at...
So what are these clauses? They go.
My Lord, if there is no conviction, then in the case of
D, E and G, for example.
My Lord, D and E and F probably all will have to be related to H. 63(1)H.
F actually talks about a declaration. D, E, and G don't. They could be. One could argue that because there is no third-party declaration, we can go into conviction area. But where do we take the declaration part?
My Lord, declaration. Now, if your Lordship looks at it in terms of section. One thing which immediately comes to mind is Section 42 of the Specific Relief Act, which talks about declaration of a legal character. Now, this cannot be that kind of a declaration because, as your Lordships have repeatedly observed, a negative declaration is impossible to obtain. Then your Lordship...
Sometimes permissible, negative declaration is permissible sometimes in some events that can be granted by the court.
There has been some revisitation or some revisitation of Alvi Sons, but otherwise that remains good law. Then if your Lordship looks at 199, that also is talking of declarations being made by this honorable court, but that's in a completely different context.
That is only.
Then what do you make out of this declaration for a court of law?
My lord, I would say that the term is not used specifically in the section 42 sense of the term.
Maybe it's a constitutional declaration.
It's a constitutional declaration, and that the declaration which the constitution is envisaging is there has been a conviction already under 63(1)(h). And then there is this gateway. He cannot file his papers before the returning officer because at that time the returning officer may refuse to accept them. But the anomaly which arises when your lordship looks at 63(1)(h) in particular, and G and H both, actually, when your lordship looks at it, for instance at H, he has been on conviction for any offence involving moral turpitude, sentenced to imprisonment for a term of not less than 2 years, unless a period of 5 years has elapsed since his release. So even a conviction which is followed by a sentence of 1 year, 11 months does not lead to disqualification even of 1 day.
Fair enough. So that's understood.
So therefore the connection which Samiullah Baloch makes between a person being an ex-convict suffering all his life the stigma that he's a convict is really not what 63(1)(h) is all about. 63(1)(h) is all about sentencing. If the person has been convicted and sentenced till the rising of the court, he's not disqualified at all.
No, but there is a difference, you see, the opening paragraph of section 62 and 63.
My lord,
they need to be read and harmonized. A person shall not be qualified to be elected or chosen. I mean, if you will read 63, a person shall be disqualified from being elected or chosen. So वो जो उसमें चीजें लिखी हैं वो आफ्टर कन्विक्शन है कि अगर कोई कन्विक्ट हो गया है उसकी सजा खत्म हो गई है तो इस इतने पीरियड के बाद वो इलेक्शन लड़ सकता है. To be elected and from being elected. This is the
correct. But if your lordship may graciously be pleased to look at clause 2 of 62, these words are used very loosely. The disqualifications specified in paragraph D and E doesn't talk about qualifications. Article 62.
But both are different situations.
No, my lord, Article 62, clause 2 is talking of disqualifications under 62. It's not talking of qualifications. So this is very loose language which has been used.
Practically interchangeable.
Interchangeable language. Because
one question which I have. DE does not have the wording there being no declaration to the contrary by a court of law.
My lord, yes.
When does D, E and G kick in?
How can they ever kick in actually in any court of law? They cannot kick in.
Or they're meaningless words?
My lord,
They're just guidelines for
they are exhortatory perhaps for the guidance of the electorate that watch out for candidates.
So first of all, you are saying that they are of no, there are no consequences which follow with D, E and F. D, E and G.
They will, my lord, D, E.
But ideally, the same wording should have been used, there being no declaration to the contrary by a court of law in D, in E and in G.
My lord,
these wordings are only found mentioned in F.
My lord, these were added in F under the 18th amendment. These words were originally not there. And the reason for adding it appears to be, as the Attorney General identified, that under F, returning officers had started disqualifying people by saying, "Aap chautha kalma zara suna dijiye." आप चौथा कलमा जरा सुना दीजिए. इस तरह की चीजें
They can still do that in E.
they can. They very much
That's
can.
the problem, you see. What we don't understand is D, E, G are there, and they're not executable as such. How could we? So, I mean, I myself read them as for the gatekeepers, as the voters, and maybe they keep that in mind and not vote because it's a subjective decision.
My lord, yes.
But cannot be enforced in a court of law.
My lord, that is what in the case of Ishaq Khan Khakwani, one of the learned judges, as my lord Mr. Justice Faiz Isa identified in Sheikh Rashid's case, took the view that no disqualification can really take place over here. These are very open-ended words. And your lordship points it out, in your dissenting opinion in Sheikh Rashid's case, where your lordship identifies the 7 questions which are to be dealt with by the court, because that's...
But Mr. Makhdoom, the problem is that I'm facing is you can't attribute redundancy to the Constitution.
My lord, yes.
Or to any law for that matter. And then secondly, you can't read into the Constitution. So the time frame, suppose if one were to say that this F applies for that election, that particular election which the nomination papers are rejected, and it ends. Now that's not written. So how, I mean, that's the worry that I have. How do we read in a time frame into it? Either we read them with 63 and create a larger timeline concept. How does it work? Or go on the validation point.
And if I may
in
just
other
add
words-
what my learned brother has just said, what I've understood from your submission is what you are saying, Samula Baloch does not accord with the Constitution.
That's the submission.
That's your argument. Can we not say that Samula Baloch for its time was good, valid judgment? However, since the lacuna has now been provided by Parliament, and they've given a 5-year time limit, both can be reconciled. That was good then, and now 5 years is. If your 5 years have expired, would you agree with that, or you would not agree with that?
No, I would absolutely agree with that, my lord. My submission is that Samula Baloch was enacted, was decided at a time when we didn't have this newly amended law. At that time, the law did not, and there was no timeline set. The Samula Baloch case was decided in a particular manner. The legislature